Prosecutors in Wisconsin say two young girls who tried to kill a classmate in order to please the horror character Slenderman should be tried as adults. The girls were 12 at the time. They lured another girl into the woods and then stabbed her allegedly repeatedly. An attorney for one of the girls says the case should be moved to juvenile court. Well, now we're getting a chance to hear from the girls themselves. Their words are very chilling. Nick Bohr with our affiliate WISN has the story.
While the two then 12-year-olds are charged with trying to kill their friend last Memorial Day weekend, the fictional creature Slenderman is also a central character. In the recorded interviews with police, for the first time we hear them explain Anissa was first to come across his tales on a website called Creepypasta Wiki.
It's full of horror stories that are meant to purposely scare you. He has these proxies or servants, as people call them.
And Anissa says once she showed the stories to Morgan, the two quickly came to believe the stories were real.
Morgan said, "Hey, Anissa, we should be proxies." And I was like, "Okay, how would we do that?" And she said, "We have to kill."
Morgan admitted the plan targeting her longtime friend was hard to explain.
She was my only friend for a long time because.
Why would you hurt your only friend?
It was necessary.
These interviews are only public because their attorneys introduced them as evidence. We wondered why they would want such an unflattering picture out in the public. Prominent defense attorney Craig Mastantuono, who isn't representing the girls, explains.
You're always a little worried about how your client presents for potential future proceedings. Here there appears to have been a decision made to present video evidence because it would support a second-degree intentional homicide attempt at this critical early stage that could get the children back into juvenile court.
That means demonstrating the girls truly believed Slenderman was real and was a threat to them and their families. In Milwaukee, Nick Bohr, WISN 12 News.
All right, let's bring in our legal guys now. Avery Friedman, a civil rights attorney and law professor, joining us from Cleveland. Although you should be here in Atlanta, but we'll make arrangements. We're going to have to, get our calendars together. And then Richard Herman, a New York criminal defense attorney and law professor, who did make his way here to Atlanta. So we will, we're throwing you a big old hug, though, Avery. Long distance.
There we go.
Okay,
there
good.
we go.
All right, very serious topic. Let's talk, now about whether these girls should be charged as adults. We're talking about Morgan Geyser and Anissa Weir. They've been charged with committing attempted first-degree murder. In Wisconsin, that automatically places the case in adult court. So, Richard, is that where it belongs? Of course, their attorneys are arguing they were just 12 at the time. This should be in juvie court, but should it?
Right.
How do you make that determination?
That's the argument. And the issue is, can a 12-year-old be rehabilitated so that they have a chance at life, to live a life? If they're tried as adults, and the prosecutor had the choice here to go with first degree or second degree. Had he charged them with second degree, the girls could have been tried in juvenile court, faced a situation where, if convicted, stay incarcerated up to about the 25 years of age, get rehabilitation and treatment. That's what they need. And then have a chance of life. If they get convicted now in adult court, charged as adults, they can get up to 65 years in prison. They're going to be in prison for the majority of their life. Is that right? That's the moral dilemma here.
So then, Avery, doesn't the argument also have to be made about whether these young girls knew what they were doing? Were they psychotic? Were they delusional? When you listen to the audio tapes, the videotapes of these young girls, at least one of them, talking about, it felt like air. It didn't necessarily feel like she was stabbing a person, but they couldn't stop. And when you hear that, you wonder, is there a medical, a mental argument to be made here of them not really physically and mentally being present at this moment? And does that assist in trying to determine whether they should be tried as adults or juveniles?
Well, and that's what the judge in this case, Frederica, is going to have to conclude one way or the other, and we're expecting that ruling on the 13th of March. For me, in terms of my service as a probation officer, the juvenile court, for my years as counsel, and even serving on the bench, I'm absolutely convinced that when you're, and by the way, the plot for the stabbing was developed when they were 11 years old. It was the 12th birthday that preceded the stabbing. But there is no way on earth. We've heard medical testimony about the incapacity of children at this age, these two girls. So it strikes me that even though the prosecutor is going to try them as adults, and there's precedent, believe it or not, in Wisconsin trying 12-year-olds as adults, I think ultimately this case belongs in juvenile court.
You do.
If there's any chance of rehabilitating these children, it should be exercised. Warehousing them for a lifetime, Frederica, is the wrong thing to do.
Huh. And you're in agreement with that too, Richard?
Well, Fred,
I guess I'm surprised to hear both of you, talk about that, because we're talking about such a heinous crime, and we're also talking about, stabbing seems like a much more passionate way of murdering somebody.
And planned.
And
It was planned.
Especially
right.
planned, nearly a year in advance. And
right.
It almost seems like, an argument can be made that maybe these young girls, even though they were just 11 in the planning and the 12 of the alleged execution of this crime, that they're also a little precocious, that, maybe they were a little bit more adult or, bigger than their years. And because, boy, this is such a heinous offense.
Well, Justice Kennedy of the Supreme Court recently opined that immature kids lead to immature acts in sum and substance. But here, Fred, one of the girls was diagnosed with schizophrenia, and it's believed by the interviews that they've had with medical personnel that they truly believed if they didn't kill this girl, their family and friends would be killed by this Slender Man. So it's
then the makers of a Slender Man, would they in any way be held, culpable, liable, being instrumental in luring or convincing these kids to do this?
I don't think so.
No.
I think the thrust here is going to be...
I think that's a great question, actually.
Yeah, but will these young girls who are now 12 years old, will they have a chance to live a life after the age of 25 if they get convicted?
Yeah.
Or are they going to spend perhaps 65 years in prison? Wisconsin's a very difficult state for this type of prosecution. They allow it, as Avery said, and we'll see.
All right, before we go, Avery, real quick, why is that? Is there a little window of opportunity there, possibly in that argument?
You know what? I think some of the parents knew that at least Morgan was involved in this. That's a question, a civil question, that really needs to be answered. We balance that against First Amendment, freedom of expression, but you know what? I think children, vulnerable kids, can fall prey to this sort of thing, and that's a question that remains to be seen, and I don't know what the answer is.
I know. All right. Avery Friedman, thanks so much. Richard Herman, and we got a nice little shot of your tie, Richard, while you're here. that was just a funny little camera
Very
move.
nice tie.
We got a little creative there. All right, good.
And thank you, Richard, for warming the seat up, by the way. Thanks for
That's right.
warming the seat
Because,
up.
we got another seat for you here, Avery. So when we get our calendars together, the three of us will be here, arm in arm. It's going to happen soon.
Wonderful.
All right, thanks so much. Much more in the newsroom after this. Thanks so much.